Mr. Hedden is here today after failing to appear before referee Snyder on January 8th, 2024. Bond is currently set at $3,827. This is the fifth bench warrant. He reports no employment. Last payment made on this account was in April of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on May 22nd, 2024 at 8:00 a.m. before this court.
Thank you. Mr. Hedden, you're before the court charged with civil contempt of court due to your failure to appear in a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on May 22nd, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, sir.
Okay. Well, I note that the current bond, based upon the amount that you owe, is approximately just under $4,000 that you haven't paid since, well, in over a year at this particular point. And what the court's going to do in this matter is I'm going to reduce your bond. You've had 5 bench warrants previously, so I have concern there. I'm going to set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
Just that I was incarcerated today. That I was supposed to. I've been incarcerated off and on for the last 8 months. I've only been free for about 3.5 now. I did 6 months here in the county jail and 2 months in Berrien County. So the day that I was supposed to show up for court, I couldn't come.
Okay.
I wrote the court to let them know I was incarcerated also.
Okay. Well, we'll deal with all of that on the 22nd. Okay. Here you go. Have a good day.
Thank you.
Mr. Parnell is here today after failing to appear before referee Delmont on February 24th, 2023. Bond is currently set at $837. This is the first bench warrant. He reports that he is employed at Hilex. Last payment made on this account was in February of 2024. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on May 22nd, 2024 at 8:00 a.m. before this court.
Mr. Parnell, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on May 22nd, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I have 120 bucks cash. That's all I have on me.
Okay.
And I missed 2 days of work, and I'm like, I don't want to lose my job again. I won't have any problems again. I'm trying to maintain employment, so I could pay child support. So I missed 2 days so far.
Okay.
And I have 120 bucks cash.
Why hasn't any support been paid since February?
Well, I work in a place called Monterey in Jones, but it was too far of a drive for me. So I found employment close to my housing. So that's what happened when I had changed jobs. So that's what happened because my last job was too far away. So now I found one that's close to home. And we're just Highlights now.
Okay. Well, didn't answer my question. Why has there been no payment since February?
I mean, I had since I lost my job in Monterey, was like we're changing jobs. I wasn't employed since February till now. I wasn't employed. So I'm trying to find employment. It was kind of a little hard because of the felonies, but I mean, now I maintain employment. Now I got a job now at Highlights, which I'm.
Okay. Well, it is your first bench warrant, so the court's considering that, and your arrearage is not exorbitant in this matter. What the court's going to do is I will reduce your bond to the amount of $100. If you're able to post that, you'd be able to be released. Do you have any questions?
No, I don't.
Okay. You're free to go. Have a good day.
Yes.
Thank you.
Mr. Stevenson is here today after failing to appear before referee Cruteau on January 7th, 2016. Bond is currently set at $525. This is the first bench warrant. He reports that he is employed at Midway Auto. Last payment made on this account was in December of 2019. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on May 22nd, 2024 at 8:00 a.m. before this court.
Thank you. Mr. Stevenson, you're before the court charged with civil contempt of court due to your failure to appear in a prior proceeding as a result of your failure to pay child support. purpose of this hearing is to set a bond that would assure your tenants at the next hearing on May 22nd, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Yeah,
Okay.
I
How much
think
can
so.
you post?
I could probably post like 1,000 or 2,000.
Okay, well, your bond currently is $525. Can you pay that?
Yes, sir.
Okay. Well, court will continue the bond at $525. You pay that bond and then you'll be able to be released, okay?
What about, because I guess I have 2 warrants.
I don't know anything else about any other warrants, only this one, the warrant in this
Okay.
case.
Well, I guess I have court again today, later this afternoon, so.
Okay, then that might be a criminal matter, but it's not impacting this case, okay?
Okay,
Okay, have a good day, sir.
Chelsea
Two.
Kilborn versus Lance Kilborn. It is Monday, May 13th, 2024 at 8:39 a.m. Attorney Thomas for the plaintiff.
Good morning to everyone.
Morning.
good morning.
Ms. Kilborn, we're going to take some testimony from you, so we'll have to have you raise your right hand and be sworn in, and then we'll
Yes.
proceed. Okay, go ahead, Ms. Thomas, when you're ready.
Thank you, Your Honor. Ms. Kilborn, do you recall coming to my office and signing a complaint for divorce?
Yes,
And at this time you signed that complaint, were all the statements in the complaint truthful?
yes,
And are they still truthful today?
yes,
Are you pregnant?
no,
And this particular case was done by a consent judgment, is that correct?
yes,
And did Mr. Kilborn also participate in getting the document signed and everything taken care of upfront?
yes,
And it's your understanding that with everything you've done, that you followed all the regulations that you've had to do, and that upon judge signing it, that you will actually be divorced. Is that correct?
yes,
Okay. One of the things you indicated in your complaint for divorce that there had been a breakdown of the marital relationship to the extent the objects of matrimony have been destroyed. There remained no reasonable likelihood that the marriage could be preserved. Is that true?
yes.
Can you please briefly describe to the court what caused the problem?
We just don't get along.
Not possible to reconcile it. The difference is if judge were to not sign.
Correct.
May it please the court.
Thank you. Mr. Kilborn, the judgment, UCSO, et cetera, are submitted under consent, meaning you've signed and approved those. Is that correct?
Yes,
And so you're not disputing, you're not contesting anything?
that's correct.
Okay, thank you. Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will enter the judgment and the UCSO in this matter, which I have done. That means you are divorced. Best of luck to both of you. I hope everything works out for you. You're free to go. Have a wonderful day.
Thank you.
Judge, just a quick question. Did you have an advice of rights too? There should have been. You didn't mention it. That's why I just wanted to double check.
I haven't
Let me double
I
check.
haven't seen that.
Okay, that's fine. Then if you guys check on, just let me know later. That's fine.
I can check here real quick. I don't remember seeing an opting out, right?
Yes.
Yeah, I haven't seen it yet, but if we have it, we will get it entered.
I don't
Okay,
have it in file, Cindy, so you may have to have that one submitted to the
Okay.
clerk and then we'll get it.
Okay, perfect. Thank you.
All right.
At 9:05 a.m.
Good morning to everyone. The court will
morning.
note that this matter is before the court on the plaintiff's motion for appointment of receiver. Mr. Zojak, go ahead.
Thank you, Your Honor. Ben Sobchak on behalf of the plaintiff, P73567. I'd like to start off by cleaning up a couple housekeeping items. This matter's moved rather quickly over the last week. Relative to our brief, I'd like to correct 2 case citation mistakes for the record. Our citation to the Reed case on page 16 should have been the Pettiprint, which was also cited at that same page. Also, our citation to the Receivership Act at page 14 should reference section 2 of 554-1024. We actually cited section 1B. The court, please would note that this all came together rather quickly in an emergency, so I apologize for those inconsistencies. Relative to the timing of everything here, the court would also note that we filed a motion to add a supplemental briefing. We were unable to get that notice up for today, and I understand that. But I would like to note that it was provided to opposing counsel the day I was made aware that they were representing defendants, and that was 2 days in advance of them actually filing their response. And lastly, I'd like to say that, the response was filed Friday afternoon. We have a Monday morning hearing. There's a lot to cover this morning. I'm going to do my very best to point out the thinness of the response on my feet today. But if at any point the court believes that it would benefit from additional briefing in this matter, Pelorus is certainly not opposed. These are somewhat complex issues, and it's a very important matter.
Okay,
So
let's move forward. I've got a lot of hearings today, so all this
Understood.
preliminary stuff I don't need.
Fantastic. Starting off with some foundational points. The defendants have been in default of the loan here for more than 10 months. There's about 10 million at issue. The loan was originally scheduled to be repaid in April of 23. The quiet title action, which is related to this, per the briefing, has been proceeding for 15 months. And my understanding is that defendants or Evolutions has yet to file discovery in that case, which is concerning. And finally, the defendants promised my client that they would settle out or resolve that case by summer of 23. And that has not occurred, which is one of the main reasons for the relief we're seeking here today. I also want to point out a couple foundational points in the response that I think are very important to the court's ruling here. Firstly, at footnote 6, page 13, the defendants note that defendant Flocken does not have 77% of the equity in defendant EGC, but instead only 7.5%. That is incredibly concerning, as we took a security interest in that equity. The first amendment to the loan agreements, which was executed in August of 22, states plainly that he owns 77%, and that is at page 239 of our entire motion and exhibit stack. The information certificate that was provided at that same time also says 77%, and the second amendment, which was executed in June of 23, affirmed all representations and warranties, asserted that no defaults were occurring, and also affirmed that the loan documents and liens were good. So we're here to talk about waste and threat to my client and their collateral. We mostly moved based on the idea of the implications of the quiet title action, but opposing counsel was kind enough to bring to our attention in their response that apparently our collateral equity interest has also been moved out from under us at some point, or perhaps the defendants were not telling the truth when they signed all three of those documents initially. Either way, very concerning. Of course, Pelorus wouldn't take an equity interest or security in 7.5% of the money-making entity in this corporate structure. It only wanted the controlling interest, 77%. So we were very shocked to read that, and I think that that new revelation further supports our motion. Continuing, the opposing counsel notes that EGC and Evolutions continue to pay their debts when due. So that's just not as to their prime secured creditor who lent money to build the entire business. This is also mismanagement. That is our collateral. The money that's being sent to these inferior creditors is our collateral. The bank accounts are our collateral. Admitting that the company is expanding and paying other people but us does not help the defendants in this matter. It is peculiar and part of the reason that we're here today. So moving on with those new things that we've learned as of Friday. We have first argued that we're entitled to a receiver based on our contract. The defendants expressly agreed to a receiver and waived any objections to its appointment in 3 different documents, and this is summarized at paragraphs 113 to 115 of our complaint, and also at pages 9 and 10 of our motion. The defendants should be stopped from arguing anything that they're doing today. They waived all objections as a condition at arm's length to be lent this money, and then for the amendments that follow. Nonetheless, the Receivership Act in Michigan specifically says that we can get a receiver connected to enforcement of a security interest or lien if the borrower agreed to appointment of a receiver on default. This is via statute. We are moving under counts 3 through 5 of our complaint for declaratory judgments as to our position on the collateral. I can't do further than that right now because the quiet title action blocks most of my other enforcement remedies, as is admitted or at least alluded to by defendants in their response. The receivership now is really our only option after a year of not getting paid, and the defendants agreed to this. We presented some case law support. We did cite the Maple Creek case, which, while though it was in Eastern District, it was interpreting MCL 600-2926, also a basis for my motion, which is Michigan law, and it says plainly, an agreement in a mortgage to appoint a receiver upon default alone is sufficient. There is little hardship in enforcing the terms of the party's bargain. This is simple at this point. They contractually agreed to this. They've been in default for a year. The law supports this. Now, what are defendants' responses and objections to this? Firstly, they argue that California law applies in this matter, not Michigan law, and so I haven't cited any California law and thus made a mistake. It is true that they cite that the loan agreements are generally controlled by California law, but if you look at the provision they're citing, it says, except to the extent otherwise expressly stated herein. And only a couple provisions later in that same document at section 1225A, which is at page 148 of my motion and exhibit stack, it says that the perfection and enforcement of liens and security interests created pursuant to hereto shall be construed according to the laws of the state in which the applicable collateral is located. Sub B of that same provision says that Pelorus can bring an action in any jurisdiction it wishes. Now, without question, my receivership request is ancillary to my efforts to execute on my client's collateral for reasons explained already, in which I'll explain more. So, the assertion that California law applies here based on the contract is false, and I don't think that opposing counsel read closely enough, frankly. But nonetheless, if we do want to talk about California Code Section 564, that's simply the jurisdictional statute in California, which is no different than our MCR 2622. And this provision, although is irrelevant, if you look at the subsections, in the response at footnote 3, they note that that provision contemplates the concept of waste, which is one of my arguments. And it also notes at subsection 9 of section 564 that a receiver appointment is appropriate when necessary to preserve property or rights of any party, including our contractual rights to our collateral and our right to appoint a receiver. So frankly, to sum it up, I don't think California law applies here at all. And I think that that was a bit of a straw man argument. But moving on, the next argument that they present in section B is that California law does not acknowledge contractual receivership remedies. In this instance, they cite to you the Turner case for the proposition that stipulation or consent does not confer jurisdiction for a receivership on the California courts. This is interesting because if you read the Turner case closely, that case concerned a rents and profits receiver, but the trial court exceeded its jurisdiction by ordering more property than just rents and profits to be committed to the receivership. The holding there is that the court exceeds its jurisdiction insofar as it purports to authorize a rents and profits receiver to take into his possession property which is not hypothecated in the deed of trust. Stated otherwise, this court was acknowledging contractual receivership rights in that opinion, and the reference to stipulation and consent wasn't in reference to the contract, it was in reference to the party's agreement at the outset of the action as to what would go into the receivership. Frankly, this is, the implications of Turner were misrepresented in the response. And if you read it closely, it doesn't do anything for the other side here, except confirm that that court was again taking action on a contractual promise for receivership. It just went too broadly. Also of interest, they cite the Barclays Bank case for the same topic. However, subsequent cases in California citing Barclays have also said, and I quote, receivers can be appointed in all cases where necessary to preserve the property rights of any party, again, sub 9 of the receivership jurisdictional statute, including when a deed of trust specifically contracts for a receiver upon the borrower's default. I'm happy to provide this case to the court. It is unpublished. The citation can be provided at your request, but the cases that they have cited, subsequent cases in California, again, confirm our position. The long and short of it is California law definitely acknowledges contractual receivership rights if it applied, which it doesn't, but either way. Lastly, on this topic, also at section B, they argue that because the receivership has to be ancillary to other relief, we can only get a receivership after we win our lawsuit. This is a huge leap in logic. Just to point out, why would the Receiver Act mandate bonds if you could never have a receiver until you already won your lawsuit and established all the parties' rights in every capacity? Moving on, they cite the Pettiprint case. I did the same thing, referencing that the receivership is ancillary to another claim. Of course, the full quote, if you read that case, is unless specifically allowed by statute. Now, I have 2 statutory cites in play here that would allow this, but that's fine because the receivership is absolutely ancillary to other claims. Let's go to the best authority that the court has in this regard. Again, the Receivership Act at 554-1016 1 sub A says before judgment, a receivership may be appointed to protect an interest in property that is the subject of the action if it is revenue producing, as it is, In fact, opposing counsel goes out of their way to tell you how much money they're making and how they're expanding and just not paying their prime creditor, which is weird. And if there is waste or avoidable transaction, I've argued a lot about waste in my motion. And since Friday, we've now found out that there may be voidable transactions because, again, they've acknowledged that Mr. Flocken's equity disappeared and also that they're paying other creditors inferior to mine with my client's collateral. So I think the Receivership Act supports here. Moving on, the Fannie Mae Maple Creek case, again, notes that in that, subject to the same objection, the holding was the plaintiff is not simply asking the court to appoint a receiver and issue an injunction. Rather, Fannie Mae has filed an action seeking to enforce its contract, note, and mortgage. Again, the idea that my claim is somehow, or my request for receivership is not collateral to our other efforts to enforce our security is false. Let's look at the defaults. The final kick here is that we haven't won our breach contract case and we've only alleged defaults. Well, the response at page 5 admits that no second extension was provided, and that implicitly concedes that there's a default because that sentence doesn't read because the loan was paid off or because the loan is invalid. And recall, less than a year ago, they signed a certificate saying that all loan documents and liens were still legit. The response at 9 offers that Evolutions will pay interest only to the court pending this matter. That does not feel like the position offered by someone who feels strongly that they do not owe my client money. And lastly, again, the Second Amendment to the loan documents signed by all defendants in June of 23 reaffirms the loan documents' validity and the validity of the liens. So there's no basis in the response for any actual colorable likelihood that they can argue that these loans are not in default, much less that my client doesn't deserve to win on the breach of contract claims. Before I continue, I'll sit down for a minute and let opposing counsel respond. That's really my presentation on the breach of contract topic as it
Oh, okay. Ms. Van Eyckson, I know when I reviewed your answer and response that you talk a lot about the title defects and a lot about the other ancillary issues, but you don't talk much about the fact that your clients are not paying. So why are they not paying and why are they in default?
So, Your Honor, they were paying for 17 months. And then as part of the, I do think the title defect is important to note because that was known by Polaris going into executing the First Amendment to the loan documents. They knew that was an issue, and it was expected by both Polaris and by Evolutions that this was a Scrivener's error that was going to be able to be corrected in a matter of months.
Regardless of that, why are they not paying?
They were paying, and then
But they stopped. Why did they stop paying?
They did stop, Your Honor, because Polaris refused to extend additional extensions without additional $120,000 extension fees every 2 to 3 months. They wanted to change fundamental terms of the loan documents. They weren't just saying, pay us monthly interest.
Why did your clients then say, hey, we're not going to do the extension. We're going to continue to pay pursuant to the earlier loan documents?
Polaris wasn't accepting. We did agree, or we did say we would pay continual interest only payments, but Polaris
saying that you're going to pay and paying are different things.
Your Honor, it was the understanding that if we were going to pay, Polaris was not going to not claim that they were in default. It was going to be pay, but you're not going to get the benefit of reinstatement of the loans. So we've said, and we've put in our documents, we are willing to continue interest only payments. We were willing to do that previously.
Okay. Why interest only and not the entire interest and principal?
There was no principal payments due.
Okay.
And then there were, we did make a $50,000 good faith payment in April. And again, we are willing to continue to make payments. That was never the question. It was all the extra fees and the fundamental changes in the loan documents that Polaris was demanding. And again, no one expected that this quiet title action was going to last as long as it did. And, one of the important things to note is Polaris at any point could have filed a motion to intervene. Never would that have been objected to by Evolutions to involve themselves in the quiet title action if they don't believe that their interests are being adequately represented. Polaris and Evolutions both want the circuit court in the quiet title action to, decide that the purchase agreement, the warranty or the legal description that was part of the purchase agreement is the correct purchase or legal description for purposes of this loan. And that remains true. And we are aggressively arguing that in the quiet title case. The quiet title attorneys are optimistic that the evidence that is set forth will go their way, but it has just taken longer than anyone anticipated. And again, Polaris knew before they executed.
Okay, I don't need to keep hearing about this. I want to
May I
hear
respond, Your Honor?
why they're not paying, why they're in default. The quiet title action may be a bump, but it doesn't keep them from paying. And that's what I'm going to focus on.
Your Honor,
May I respond, Your Honor?
In a minute.
Yeah, thank you.
Your Honor, again, we are willing to pay, and non-payment does not equate the necessity of a receiver. Again, the allegations that they're asserting for why they need a receiver is collateral dissipation. They are fully secured. Yes, we're paying bills as they become due because it's an operating entity. Of course, we should be paying those bills. You're allowed to pay bills in the ordinary course of business, and it's expected to do so. Otherwise, we would never get any supplies if you don't pay your suppliers.
How much do you owe to plaintiff for that 10 months where payments have not been made?
I believe interest-only payments are just shy of $100,000. Mr. Sopchak, is that correct?
That's roughly correct. 90 to 100 a month. So I'd say about 900 to $1 million.
Mhm.
Now, if I could respond, if you're done.
I said in a minute. I want to focus on what's owed at this point.
Your Honor,
Clarify, she's saying it's just shy of 100,000 and you're saying 900 to $1 million.
No, it's 100,000 a month, Your Honor. So we're
Okay.
talking at least 10 months. And to be clear, the loan required a balloon payment of all principal in April of last year, which is extended to July, and that's it. So all the money has been due. We sent a notice, we accelerated. Like, my client doesn't have to wait. Like, this loan was underwritten based on time and interest. It is a failing of our portfolio. The opposing counsel's position that they can just renegotiate by stopping paying and using the quiet title action as a shield is exactly why I want a receiver to run that case, because we're not convinced that it's being handled for the right reasons. And opposing counsel in that case for the Howlands seems to support this proposition, which is bizarre, but for the fact that they also don't want to litigate a case that's not being litigated for its purpose, but specifically to box out my client's remedies. And that's why we're here today.
Ms. Van Eytzen, he's saying that there's approximately $1 million that's owed. Why are you at 100,000? He's at $1 million.
it was $100,000 a month, Your Honor, were the interest-only payments.
Okay. Well, when I asked you how much was owed, I didn't ask you how much per month. I asked you how much is owed.
I'm sorry, Your Honor. I think it was just shy of $100,000 a month. So for 10 months, it would be between 900 and.
Is your client able to pay the $1 million in those interest-only payments at this point?
As a lump sum payment, Your Honor?
Yes.
I will have to ask. I don't know what their liquidity is. They may need to receive money from investors, Your Honor. I don't know if they've got $1 million sitting there.
They're not allowed to receive money from investors because the collateral is my client's, the equity is my client's collateral. All of the loan documents do not allow you to bring in other equity without approval of Polaris, which is frankly denied because the entire 10 million has been due for a year. So no. You don't have $1 million right now because you've spent it on other things, including bragging about how you're opening an 8th flower room, which is astonishing to me that you're expanding your facility while not paying the person who lent you all the money to start this business. And you think that actually supports your case right now. You don't have the $1 million because the business is not ever planned to pay my client, which is why I need a receiver to do the right thing for all interested parties now.
Your Honor, may I respond?
Yes, go ahead.
Thank you, Your Honor. Your Honor, growing the business only helps Polaris. They have an all asset security filing on EGC's inventory personal property. So all the additional plants, all the additional lights will benefit Polaris. The increase or the real property, Polaris has a title insurance covering the full amount of their debt. They are not at risk of losing what they are owed. They are fully and over secured. A receiver is a last resort remedy that is only appropriate if less intrusive means are not available to them.
It's appropriate if your clients are in default, so.
Your Honor,
And
but
it's
we have defenses to that default. Polaris entered into this First Amendment understanding that there was a title defect
Again,
that had to be changed.
please don't keep arguing the title defect to me, because I don't care about that part of the case. I care about what's owed and why it's not paid and why are we in default.
It was we were paying, Your Honor, until they started demanding $120,000 extension fees every 3 months on top of the interest-only payments that were due. If
Then
all
there's no extension. Then there's no extension, and just follow our agreement. There's extensions aren't free in financed transactions.
Your Honor,
Okay.
I would also go with the receiver. All of their concerns relate to evolutions. EGC has committed no waste with their collateral. They continue to operate profitably and will pay and have agreed to pay interest-only payments while they until the dispute in the other action can be resolved. A receiver is only a last resort remedy. There are other remedies available that we are willing to make, have been willing to make. They have not been accepted. And there are defenses to the claims that they are making. They have an inherent requirement of good faith and fair dealing that we do not believe that they've met. We are willing to make payments, and a receiver does not resolve any of the issues that they're asking for. There are less intrusive means. If they are concerned with what is going on, which are the only issues that they point to for why appointment of a receiver is necessary, is the actions that are going on in the quiet title case. They can intervene. They have made no allegations of embezzlement, wrongdoing, the typical reasons a receiver is appointed.
I just did, because you informed me that your
Okay,
client.
hold on.
moved
Okay,
68%.
I don't need to hear any more, and I don't want to hear any more bickering either. What the court's going to do in this matter is the court notes that the documents all provide for appointment of receiver as well as waiving bond in the event that it's necessary. The court then notes that the statutes providing for the appointment of receiver allow the court to equitably appoint a receiver in this particular matter. And at this particular point, for whatever reason, the defendants have felt that they have entitled in some way to simply stop paying. What the court's going to do is I am going to reserve on the appointment of a receiver at this time. The court is going to give the defendants 30 days to bring all of the interest payments that are owed at this point current, as well as to continue the current interest-only payments. If in fact the defendants do not pay the back amount within the 30 days from today's date, and do not make the current interest-only payments, then the court will allow the plaintiff to renew their motion at that time, and the court will at that point consider the appointment of a receiver. So Mr. Savchak, you can do an order to that extent and submit it under 7-day notice of entry.
I will, Your Honor. May I add one thing?
Yes.
I appreciate the court's wisdom in going with this approach. I think it's very fair. I would note that opposing counsel conceded in the response that a receiver could be appointed over evolutions relative to the quiet title case that's apparently causing all this trouble. I would ask whether or not the court would consider appointing a receiver simply for that case now during these 30 days. I feel confident the case won't be existing by the end of the month.
I'm not going to get into another case that is not before the court today.
I understand, Your Honor.
Promotion. So you can prepare
we'll
to submit
submit
that
the
under 7-day.
Thank you, sir.
Okay, thank you.
Thank you, Your Honor.
All, you're free to go. Have a good day.
Thank you.
Court will note the appearance of Mr. Todd on behalf of the plaintiff, Ms. Zubak on behalf of the defendant. This matter is before the court on the plaintiff's motion for contempt regarding property. Mr. Todd, have you received and reviewed the answer in this matter?
I did, Your Honor, just this morning.
And in fact, the answer states that the defendant has signed that particular listing agreement. So again, at least that aspect of it is resolved. Is it? Don't you agree?
Your Honor, it is. And the reason why we wanted to keep this hearing on was, I guess, 2 reasons. One, the fact that we needed to file this to actually have him sign that agreement. Additionally, we are requesting that an order indicate he would continue to facilitate any aspects necessary for the sale. We have concerns that if the agreement's signed, that's that, and then he will, in essence, kind of thwart any sale.
Okay, Ms. Huback, any problem with having that to say that he'll further cooperate in the sale of the property?
There's no problem with that, Your Honor. My client's happy to cooperate and he has been cooperating. So I don't think an order is necessary to get him to cooperate. As is reflected in my response to the motion, my client's happy to do whatever he needs to do to follow the order.
Well, what we'll do, Mr. Todd, you can do an order state that further that he will cooperate as necessary to affect the sale of the property, and the court will reserve on the attorney fees at this particular point. Mr. Todd, you can submit that under a 7-day notice of entry.
Absolutely. Thank you, Your Honor.
Okay, thank you. You're free to go. Have a good day.
Have a good one.
Thank you, Your Honor.
Court will note the appearance of Ms. Oatman on behalf of the plaintiff, Mr. Holak on behalf of the defendant. This matter is before the court on 2 motions by the plaintiff, one for exclusive use, the other for a financial restraining order. Ms. Oatman.
Yes, Your Honor, I believe that we were asking for exclusive use of the marital home, and as well as that, we were also asking for temporary orders regarding custody, parenting time, and support. That was noticed out with the same exclusive use motion and temporary spousal support motions.
Okay, that may have gotten lost and the clerk didn't forward it some because I had the other 2 motions.
All right, Your Honor, we did receive a response from opposing counsel on all 3 motions.
Okay, go ahead.
Thank you. We are asking that the court grant joint legal custody. I believe the other side will agree with us on that provision. We're also asking that they continue their temporary involuntary parenting schedule that they have established between the 2 of them since defendant moved out on March 30th. He has been residing with his mother, and since he is no longer in the marital home, we are requesting that the plaintiff mother receives exclusive use of the marital home. She is willing to make arrangements for Mr. Kunkel to have access as needed, but she would like to be able to have that order that says she has exclusive use. She would also like to be granted temporary primary physical custody of the children, and for the parenting time schedule to basically consist of father having the children on the Sunday and Monday overnights that he's been exercising, the midweek visit, which they've been doing on Tuesdays, and for that to continue as a temporary order. We are asking for $152 a month in spousal support for temporary spousal while my client looks for more gainful employment. And we are asking for friend of the court to issue a calculation on child support or for the attorneys to work out child support arrangements between counsel. Thank you.
Mr. Holek, obviously the parties are separated now. That's different than at the time the motion was filed. You have any problem with the exclusive possession issue?
I don't believe there'll be an issue with that, Your Honor, as long as my client can visit the premises as needed to pick up items of his that might still be there, and of course to pick up or drop off the children.
Well, there'd be no problem for pickup and drop off of children as it relates to the other. He's going to have to give advance notice through the attorneys before the court will just allow him to come and go to pick up property. So the court will grant to plaintiff exclusive use of the property with that provision that he would, coming to pick anything up that would be cleared through the attorney's offices. What do you say about the continuation of the parenting time schedule that the parties apparently have utilized since March 30?
Your Honor, my client would oppose that as articulated in our response to plaintiff's brief. We would be asking for 50-50 parenting time. My client works, but he still would have plenty of time to take care of the children during the hours that he would have with them. The parenting time at this point was a courtesy from my client to minimize any friction from the separation. However, he loves his children and he wants just as much time with them as the opposing party does. So we would ask that 50-50 parenting time be awarded.
Okay. Ms. Oatman?
Yes, plaintiff would like to request that the schedule at least temporarily be what they've been exercising for one reason, because Mr. Kunkel does work at a casino and so he has late hours and he needs to sleep too, and he cannot exercise parenting time while he's trying to sleep per se, and the children aren't because they're not on the same schedule. And I understand his mother does have daycare, so we're not opposed to him having adequate time with the children. We are opposed to switching up the schedule at this moment.
Okay, well, when the parties have the children in their respective care, they can take care of it the way they wish to. I'm not going to dictate when he sleeps or when he doesn't sleep. So what to do is the court is going to grant to the parties. It looks like he's been exercising the parenting time Sunday overnight through, it looks like Tuesday. He's had Tuesday overnight as well.
No, he has not.
Well, you said he had Sunday, Monday, and he has Tuesday.
Yes, sorry, my apologies. Sunday is actually just a few hours in the afternoon. It is not a full overnight. Tuesday, my apologies. Tuesday is the midweek instead of a Wednesday.
So Tuesday is a midweek and not an overnight.
Correct, Your Honor.
Well, what the court's going to do is the court is going to grant to the parties a joint physical custody as well. And the court will grant to the defendant parenting time Sunday. We'll run it Sunday. Well, let's do it this way. Let's do it. We'll do Sunday from 12 o'clock noon through Tuesday at 8 o'clock p.m. And that will be his time. The other times will be with the plaintiff. And the court will allow the parties to exchange income information and then calculate support at this point. The court is not prepared at this time to grant any temporary spousal support until such time as the court can have a hearing and review all of the factors that the court needs to do pursuant to Sparks and Louts. So that will be the order, Ms. Oatman, and you can prepare that and submit it under 7-day notice of entry.
Very good. Thank you, Your Honor.
Thank you. You're free to go.
Your Honor, I apologize. Could you broke up briefly on your stream? Could you please state the hours of parenting time again? It was Sunday at 12.
Until Tuesday at 8 o'clock p.m.
Thank
I
you.
guess the court would add too, I would add the standard holiday parenting time in the event that we don't get back in until, as being that we're coming up on Memorial Day. And then the 4th of July, we might not be back in before that. So the court will alternate the standard holidays as well.
I will add that in. Thank you, Your Honor.
Thank you.
Thank you.
Lisa, is your client Ashley plan on appearing this morning?
Well, I got a message from her that said she was coming to my office, and last I knew she was not here, and even though we have a separate Zoom room set up for her, we can move ahead without her though.
Do you see Ashley Sprague versus Zachary Swanson?
Court will note the appearance of Ms. McNiff on behalf of plaintiff. The matter is before the court on plaintiff's motion for temporary custody, parenting time, and support. Ms. McNiff.
Thank you, Your Honor. Your Honor, when this case was first filed, there was a PPO in place due to a couple of incidents of domestic violence between the parties. Ms. Sprague set aside that PPO in order to try to co-parent in a better manner with Mr. Swanson. In addition, my understanding was that Mr. Swanson had been employed at Speed Rack in Quincy as a welder. He lost that job. I don't know if he's employed at this point or not. If he is employed, I don't know how much money he's making, what his income should be. The parties, to my understanding, have been exercising parenting time with Mr. Swanson having the minor child from Friday at 4 until Sunday at noon. And my client would like to maintain that schedule along with standard holidays. The child's young in this case. He's only a year old. So I would appreciate holding up yet on the summer vacation period until maybe we can get back into the court and make those determinations and find out a little bit more about where Mr. Swanson is working, if he is working. He had been on a 3rd shift job, which might be difficult to manage with a 1-year-old.
Okay. Mr. Swanson, what's your response to the motion?
Your Honor, I'm currently not working right now. I'm actually waiting on a phone call from a job, and I agree with what she says. So,
okay. So you're agreeable to the plaintiff retaining custody with you having parenting time the Friday through Sunday?
Yes, Your Honor.
Okay. Well, that sounds like that's resolved then, Ms. McNiff. Court will grant, I'll grant to the parties temporary joint legal custody with primary physical custody to your client, Ms. McNiff, with the parenting time from Friday at 4 o'clock p.m. through Sunday at 12 o'clock noon, as well as the alternating holidays at this particular point. The court will, what I will do, Ms. McNiff, is have the support can be set considering imputation to the defendant of $15 per hour. And you can, in fact, prepare a UCSO to that effect, as well as utilizing your client's income. Anything else, Ms. McNett?
No, Your Honor, thank you.
Mr. Swanson, anything else?
No, Your Honor, thank you.
Okay. Thank you. You're free to go. Have a good day.
Yep, you too. Thank you.
At 9:49 a.m.
Well, I know for plaintiff, you're not Ms. Paisno. Would you identify yourself for the record?
Yes, good morning, Your Honor. Attorney Sydney Jordan here on behalf of Attorney Leslie Paisno, who represents the plaintiff David Bell, who is also present on Zoom.
Okay. And the defendant is appearing in pro per. This matter is before the court on the plaintiff's motion for temporary custody and parenting time. Ms. Jordan.
Yes, good morning, Your Honor. It is our understanding that the parties actually have a final agreement.
Okay.
And as such, we would request that we place that on the record this morning, and then my office will prepare the judgment accordingly.
That's fine. Go ahead.
So the parties would share joint legal and joint physical custody of the minor child. There is one minor child in this case, Sophia, age 11 months old. The parties would request to exercise the right of first refusal only when one parent is working, and then the child would be returned after that parent's work shift. That there would be no child support ordered at this time for either party. The parties would exercise parenting time on a 2-week 2-2-3 rotation, beginning this week with mother having Monday, Tuesday, father having Wednesday, Thursday, then alternating the weekend. This would be Mother's Weekend, Friday to Sunday. Next weekend would be Father's Weekend, and rotating thereafter. That the parties agree to split holidays and special occasion parenting time by splitting the holiday itself, with one parent having the morning and one parent having the evening, or the first half and the second half. That this split would be by agreement of the parties, and that if they cannot agree, that in even years, dad would have the first half of New Year's Day, Memorial Day, Labor Day, and Christmas Eve, with mother having the first half in odd years of New Year's Day, Memorial Day, Labor Day, and Christmas Eve. And then in odd years, father would have the first half of Easter, 4th of July, Thanksgiving, and Christmas Day. That Mother and Father's Day would always go to the mother or father. In this case, the parties are including the minor child's birthday in this holiday special occasion split/rotation. And I believe that that is the entirety of their agreement.
Okay. Ms. Jordan, do you know, are either of the parties on any public assistance?
Not to my knowledge, Your Honor.
Okay. Ms. Murray, are you receiving any public assistance on behalf of minor child?
Yes, she is on Medicaid.
Okay, if she is on Medicaid, the court cannot waive child support, so there will have to be child support paid pursuant to the respective incomes of the parties.
Yes, Your Honor.
With that, Mr. Bell, is that your understanding of what the agreement is?
Yes, sir, Your Honor.
Okay, and you understand that you can't waive child support when public assistance is involved?
Yes, sir, Your Honor. I understand.
Okay.
No.
And you're agreeable to, again, an order which would recite the agreement as provided by Ms. Jordan?
Yes, Your Honor.
Okay. And are you doing so freely and voluntarily, sir?
Yes, sir.
Okay. Ms. Jordan, would you inquire of your client?
Yes, David, if you could please turn on your video, and then, Your Honor, if you would swear him in.
Oh, I'm sorry, that was Mr. Bell that was talking when I was asking Ms. Murray that.
It was.
Okay. Got him confused, okay. Ms. Murray, you understand the settlement is placed on the record by Ms. Jordan, as I clarified, as it relates to the child support?
Yes, Your Honor.
And is that agreeable to you?
Yes, Your Honor.
Okay, and you understand if you'd have proceeded with the hearing, a different result could have occurred, could have been better result for you, a lesser result, or the same. And notwithstanding that, you agree to be bound by an agreement as set forth on the record.
Yes, Your Honor.
Okay, thank you. Looks like, Ms. Jordan, that your client's already agreed and put that on the record, so I'm not going to need to do that. We don't need to have it sworn once it's put on the record, any event.
Thank you, Your Honor.
Okay, Ms. Jordan, we'll leave that up to you. You can prepare the order, submit it to the other party, to Ms. Murray and to the front of the court for approval, and then submit it to the court.
Excellent. If I might, just briefly, Your Honor, Ms. Murray, do you have a good email address that we can use to send this to you?
Why don't
Yes.
you do this, Ms. Murray, just so you don't put it on the record, so somebody has that, because it is streaming. Would you provide Ms. Jordan with that after your leave? Okay.
Thank you. We'll have my client reach out to you, Ms. Murray, with my email address so that you can provide it to counsel.
Okay.
Okay. Thank you.
Thank
Free
you,
to
Your
go.
Honor.
Have a good day. Court will note the appearance of Mr. Gilbertson on behalf of the plaintiff, Mr. Bolton on behalf of defendant in this matter. We have Mr. Lance in it, but he's not here. Could you enlighten me is Mr. Lance intending to be here or doesn't need to? Because it's defendant Millennium's motion to set aside default and default judgment.
Good morning, Your Honor. For the record, Ian Bolton on behalf of Millennium Sustainable Ventures Corp. Your Honor, I do not believe Mr. Lance filed any response to the motion. I haven't spoken with Mr. Lance at all, and I don't believe he takes a position on this. My suspicion is he just didn't show up because he doesn't have anything to add. That being said, Your Honor, I didn't speak with him, so I'm not sure.
Okay, I'll just ask you, Mr. Bolton, you stated that the default and the default judgment were against a party that's name was incorrect. It's not your client's name. So if the judgment is not against your client, why do you need it set aside?
It's a really good question, Your Honor. I spoke with my client about this. You mean the name on the complaint differs from the name on the default judgment, differs from the name on the proof of service, differs from my client's name. But they're all really close. And I assume once they obtain the default judgment, they will try to collect on the assets of my client.
Well, being really close, as you know, in the law isn't accurate. So
I understand, Your Honor. The other option was just to let them have their default judgment against this made-up entity and good luck trying to collect on it. But I didn't want to fight it later. I thought if we know what they're trying to get to, so we thought we'd get it set aside and deal with it now. But that being said, Your Honor, if the court is of the opinion that just let them have the default judgment against the made-up entity and then start over against my client one day, that's fine too.
okay, Mr. Gilbertson, what's your thought?
Yes, thank you, Your Honor. Really the issue here is that the entities that have been named have all been identified by Mr. Bolton's CEO, his client, David Lesser, who's also the CEO of the other entities. So to the extent that he can't keep his entity's name straight and then now is using that as an umbrella to say, hey, you can't come after me because you had it misspelled or you had, also known as, and that's a sub-entity, not that, it's a complete shell game here. I think our response made that very clear.
Well, but the fact is you didn't get the default and the default judgment against the proper defendant. Is that accurate?
Well, the default judgment is against Millennium Sustainable Ventures Corp.
But the name is misspelled.
With one N, and that are multiple times back and forth in correspondence from Millennium Sustainable Ventures Corp with two N's in it. And those are the emails back and forth.
Well, regardless, I'm talking about the judgment. I don't care about any emails or correspondence or anything of that nature. The fact is you have a default judgment against an entity that is not a party to the case.
Your Honor, I think the case law we provided on misnomer is clear, that misspelling an entity's name by a letter when they have actual knowledge of the case does not render a default judgment as invalid.
Well, what happens is, in this case, is the court obviously wants it to be accurate, correct? I'm not going to make those types of inferences in this and just assume that because somebody had misidentified or somebody got it right. I guess the only thing I can do, Mr. Bolton, is in this matter is the court is not going to set aside a default against a non-entity in this case. But if you feel better, the court would state simply that the plaintiff cannot execute against your client on this particular default judgment.
Okay, that works fine with me, Your Honor. I'll submit an order.
Okay, thank you. You can submit under 7-day notice of entry. Thank you, gentlemen. You're free to go. Have a good day.
All right, you too.
Court will note the appearance of Mr. Zhang on behalf of the plaintiff, Ms. Henderson on behalf of defendant. This matter is before the court on the plaintiff's motion to set aside referee order in this matter. Mr. Zhang.
Good morning, Your Honor. I apologize. I was hired onto the case like 3 days before the deadline for filing the motion. So a lot of the details I did not have until I had to file the objection, or sorry, the motion on time. Just to inform the court, one part of the reasons that we're seeking for this motion to vacate is because there are some there's some significant deficiencies in the evidentiary hearing conducted by the referee. My client was not allowed to call any witnesses to show the relationship between Mr. Henke and the minor child. My client was not allowed to present some of the evidence that she wanted to present. The referee overlooked the fact, or at least disregarded the fact that the minor child and Mr. Henke hasn't seen each other for 4 years, since 2020. And even though the parties actually agreed on a graduated schedule, the schedule, the parenting time schedule awarded by the referee is just lightning fast. It is not in the best interest of the child for the minor child to have overnights after just 3 visits, 3 in-person visits with Mr. Henke. My client's not asking for no parenting time for Mr. Henke whatsoever. My client is just simply asking for a more graduated schedule so that Mr. Henke and the minor child could be more accustomed with each other, rebuild that relationship before we jump into this full parenting time as awarded by the referee. Therefore, we're asking for the court. Oh, I'm sorry. There's also the issue of domicile. Back in 2018, my client came in court asking for a motion, filing a motion for a change of domicile, and that was granted by the court. The referee stated in the recommendation that the domicile should be with Michigan and should not be removed. That is also an error that should be fixed. Therefore, we're asking the court to vacate the recommendation order to schedule a full evidentiary hearing in front of Your Honor, and any other relief Your Honor feels appropriate.
Okay, thank you. Ms. Henderson, on that last point that the court had previously granted a change in domicile, why would that part at least not be appropriate?
Your Honor, I did not object to that part. Again, in my response, I stated that it appears to be a harmless error. The domicile has been changed. We have no objection to that. It's my understanding that was possibly a typo by the court. To respond to Mr. Zhang's objection, if he had ordered the transcript and he reviewed the transcript as is required by this court, he would have heard and seen that his client was given multiple opportunities to comply with the scheduling order. We had 4 hearings that were continued, and she did not comply with the scheduling order by providing the witness list and exhibit list. Therefore, at the last hearing, she was deemed to not have complied with the order and was barred from the testimony or other presentation of proofs. The claim that she was not allowed to present any evidence, again, is improper because she did not comply with the order. And if any evidence was presented and was objected to, the objection, if granted, was proper and therefore barred the evidence as well. So that claim, Your Honor, is simply Ms. Coolidge not liking the result of the referee hearing and essentially throwing a temper tantrum. I don't know how else to classify this objection, because she had ample opportunities to comply with the scheduling order and present evidence, but she chose not to. Specific rulings were given by referee Snyder on the record as to the reasoning for the parenting time that he granted. Specifically, the distance between the parties, the age of the child, the amount of control that Ms. Coolidge wanted to exercise and would not agree to any contact between Mr. Henke and the child were all taken into account. And that's why the parenting time ordered was what it was, Your Honor. It's unusual to see as part of the order that requirement for the parent to speak with the other parent before speaking with the child is unreasonable, yet the referee deemed it appropriate to include it in the order, again, given the evidence that was presented. Your Honor, again, I would ask for the court to deny this motion. There's not any error or specific unfairness that is listed by the objecting party. There's no transcript that was ordered. The plaintiff in this matter simply did not comply with the scheduling order and does not like the result that followed that. I would not object to an order clearing the harmless error as to domicile, but again, that's the only thing that we would not object to. Further, I would ask the court to deem this motion frivolous, as it clearly is devoid of any legal argument or does not specify what the referee did wrong, rather than simply stating that the mom does not like the parenting time schedule that was ordered. I would ask for the attorney's fees to be granted. For this court's indulgence, I would also mention that in about 24 minutes, we're scheduled with referee Snyder on our motion to hold mom in contempt, because as a result of the order entering, she did not show up to the first two parenting times that were ordered by referee Snyder. She simply refused. And I think the court needs to know that. Again, this is mom's attempt to block any contact between dad and the child in this matter, Your Honor. Thank you.
Okay, thank you. Mr. Zhang, if your client, there were 4 hearings, she had multiple occasions in which she could have filed a witness list or exhibit list, et cetera, and she didn't do it. How is she able to complain now when she didn't comply with the scheduling order?
Well, Your Honor, even if Your Honor would be inclined to hold my client responsible for not filing the correct witness list and the exhibit list, there's no question that Mr. Henke and Miss Henderson agreed that the minor child hasn't had any contact with Mr. Henke for 4 years. The error is with the referee's decision to discount that fact and to not hold that fact as a central issue to when determining parenting time.
Okay, thank you. Well, just because the referee doesn't agree with the party doesn't mean that it's an error in this particular matter. Court notes that her objections were she was not able to call witnesses, not able to present evidence, and yet she had 4 hearings and none of which she complied with the scheduling order, which required her to disclose those witnesses and those exhibits in this matter. She can't now come in and complain about her failure to comply in these particular cases. So, no, ma'am, you've got an attorney. I'm not going to listen to what you have to say.
He just wasn't informed, so that's why there's things that he doesn't know.
Ma'am, do not talk. You have an attorney. Your attorney will talk for you. So in this particular case, obviously the court does not find whether the referee made a factual or legal error in this matter, except as it related to the domicile. So the court will, again, deny the motion to set aside. That means that order is in place, it is enforceable, and if parties do not comply, they can be held in contempt of court. The court will allow you, Mr. Zhang, to, again, enter an order for the change of domicile. You can submit under a 7-day notice of entry to correct that issue, but otherwise the court will submit an order denying the motion in this particular matter. I'm not going to award attorney fees, Ms. Henderson, only because, again, we had to correct the domicile issue, and as a result, we have done that. So I don't believe that attorney fees are warranted at this time. So
thank you, Your Honor. May I please ask another question?
What?
May I please ask another question? Last week,
Sure.
we appeared in front of you on the same case on child support issue, and that issue was referred to the referee for a continued hearing. Again, that was part of the ruling, and the child support ruling on that matter was very clear, Your Honor. I would ask for that issue to also be removed from the referee docket, simply because it has been adjudicated, and the objection that Ms. Coolidge should be imputed at Indiana's minimum wage was specifically addressed at the hearing, and that's why she was imputed at the income she was imputed.
Yes, go ahead.
We already received the order of referral from this court as a result of the last Monday's hearing. Ms. Henderson is basically trying to ask you to basically try to make a oral motion for you to reconsider your decision. I'm asking your court, Your Honor, to deny her request.
Well, I'm not going to reconsider anything. The fact is, whatever the court did last Monday will stand. It will be the order of the court. So.
Okay, thank you, Your Honor.
Okay, thank you.
Have a good day.
You too.
2024 at 10:42 a.m.
Thank you, Your Honor.
Court notes that this matter is before the court on the defendant's objection to the referee order in this matter. I know your objection, Mr. Best says, well, I want this. Well, that's not a basis for objection because of what you want. It's a matter of that the referee made a factual or legal error. As it relates in this matter, you stated that the referee did not take into consideration another child for which you're paying child support. The court would consider that a factual error in this particular matter. You said that you're paying $668 per month for that child. Is that accurate?
Correct.
Okay. Well, you should be given a credit for that amount in calculating the support obligation. Is there anything else, Mr. Bass?
Well, I would just go back to the time with the child. The time with the child the past 2 months has been 50%, and so that was a factual error.
But the referee granted custody to plaintiff, correct?
Correct.
Oh. Mr. Bass, is that accurate?
Yes.
Okay. Why? Just because you've had the child more than you had prior to those 2 months, why there's no requirement that the referee affirm and ratify whatever you're going through? I guess I don't see how you're saying that the referee made a factual or legal error just because it's not what you want.
No, if we're everything, the paperwork I filled out, and when they asked us in the hearing, talked about the past year, and in the past year, I've had the child overnight more than the 104 nights. It was the most, at the time of that hearing, it was the most recent 3 months. Circumstances changed. I left a job at the other side of the state to move back here for that reason. And me and Anita agreed on a schedule. And since then, it has been 50% of the time. And so that's where it is a factual error.
Okay. Ms. Harvey, what's your response?
Yes, please, Your Honor. So we agreed to create a parenting schedule that we both could live with. Mr. Best submitted a schedule as of April 24th. And I agreed that month by month, we will determine what will be in the best interest of the child. So we've only determined April thus far, and May, as a matter of fact. He mentions that he's had the child more than the 104 days. Well, that's not true. I've had some extenuating circumstances personally in my family, with my sister being diagnosed with cancer, that required me to travel quite a bit, in addition to my work obligation, which is an annual conference once a year. So I believe we can work out a schedule that will accommodate the 104 days, because our daughter is 3. I'm in the midst of potty training, and I have to have a structured environment to keep that going. So I was under the auspice that 104 days would work in the best interest of the child, and he and I, Mr. Best and I, can determine those days.
Okay. Well, as it goes to your question on the potty training, the court's not going to set a parenting time schedule based upon potty training or teaching them how to ride a bike or anything else that may come up. Again, when there's a schedule in place, that schedule is etched in stone until it's changed. The two of you can change it, that's true. But if you don't, and if you don't change it, then it's whatever the referee had ordered, and that would be the schedule. So,
Judge, may I clarify? The referee left it to us to determine the schedule. There wasn't one introduced.
okay. Well, I understand, and maybe the referee wanted some flexibility. I understand that as well. And apparently the two of you have gotten along such that he would be entitled to those particular 104 overnights. I would say, just for your edification, if you can't agree to that, and let's say we came in, let's say you allowed him to have no time or very little time throughout the year, and we get into November and he's only had, let's say, 20 some nights or something of that nature. The court's going to give him the rest of those months to make up to the 104. So be aware of that. If you don't cooperate and you don't work it out, then you may go a couple months without seeing the child. So just mentioning that. So you can't just not provide for parenting time just because you don't want to. That's going to hang over your head, and that's what's going to be the order in this matter. So, sir, you had something else?
Yes, I was just, is there a way that we can go in front of someone to help us with the schedule? Because I had presented the schedule. Her first reaction was great. That's perfect. But then, like, we're not at a spot where we can agree. I had laid out the schedule that she initially said was okay, but because of a night being inconvenient, I just not allowed to take my child, and that just, it makes it very difficult. And we're not in an area where we can do that, I feel, on our own, because it's just up to her and when it's convenient for her.
Okay. Well, obviously these things get into who's it convenient for. Is it convenient for the person proposing it or the person objecting to it? And I'm not going to, again, say just because she objected and maybe had a reason that it's, that it's basically not appropriate. What we'll do is, in this particular matter, if you're going month to month, the court will modify it a little to say the parenting time that's ordered by the referee, that the parties will, in this case, Mr. Best, that you will provide her with a schedule by the 15th of each month for the following month. So in this case, we would not be past the 15th of May. So you'd provide by May 15th, you'd provide her with the schedule that you want for June. Okay. She'll have 10 days after you submit that to her to respond. Well, I won't even say 10. She'll have by the last day of the month, she will have to respond to you in writing, meaning you'll have to get that by the last day of the month. You don't send it out the last day of the month. He has to receive that by the last day of the month. So, and in the event that she does not notify you of an objection within that time, sir, then your proposal is going to again be the schedule that you have to follow. So if she doesn't object, she doesn't send a counter proposal or something of that nature, then your proposal would be the governing one for the following month, and the parties would both have to live with that. If she does object, you still have to try to work that out, and if not, then you'll have to go to the front of the court, and the front of the court will mediate that particular issue. If it got to be too difficult, where month after month there's always objections and always issues, then the court will put in place a schedule that would be, in essence, etched in stone, that the parties don't have any control over at that point. So that will be the order, Mr. Bass. With regard to that, you're going to have to prepare an order which would recite what the court has said here today. By you submitting by the 15th, by the end of the month, that she has to object or make an alternate proposal. And if she doesn't, then your proposal would in fact govern at that time. Okay?
So how do I petition for joint custody?
Well, you can petition for joint custody by filing a petition with the circuit court clerk's office. Okay? Right now, we're dealing with the referee's order, and what you're going to have to do to modify that issue on the parenting time, submit an order, sir, because again, when you represent yourself, you have to do what the attorney would do, which would be prepare and submit an order. So you're going to have to submit an order. You're going to have to do it within 7 days of today's date for that order to get entered. And if she has a right to object, but only objecting to if it's not validly reflecting what the court said today. She can't object because she doesn't like it or I don't want to do it this way. She can only say, nope, judge, you didn't order it that way. He put down that for whatever reason, something else in the order. But as it relates to the other, taking into consideration your other child adjustment, the court will refer that back to the referee, and the referee will adjust child support accordingly. Okay? Anything else, Mr. Best? Ms. Harvey, anything else?
I would like to add, Your Honor, as we look at the objection to this order, Mr. Best also stated that his monthly income was inaccurate, but he also did not disclose all of his income.
Well,
So,
I don't know that, and if in fact he didn't disclose and there's a fraud on the court, you have a right to raise that by appropriate motion for modification, but you have not filed an objection to that effect, ma'am. So as a result, the court can't consider anything you just choose to bring up at a hearing without providing the other side with notice of that. So.
well, I was just saying in his objection, he wanted the income adjusted, but I'm hearing you say that that's not going to be a consideration.
It's not going to be a consideration.
Okay.
Okay? We're going to adjust the fact that he didn't get a deduction for other child adjustment, though.
Understood.
Okay. Thank you. You're free to go. Have a good day.
Thank you.
People Driven Credit Union versus Orbit Marketing LLC, and for other defendants, Attorney Zausmer for plaintiff, nobody here for the defendants.
Mr. Zausmer, enlighten me. What's happening in the case?
Good morning, Your Honor.
Afternoon.
Your Honor, on Friday, I received an affidavit. So in short, I have been unable to serve the defendants, Your Honor. As soon as the case was filed, I submitted it to a process server in the area to effectuate service. On Friday, I received an affidavit from him. He indicated that, I'll try to be brief, Your Honor. He has attempted service on Mr. Thompson, who is the principal of all of the corporate defendants and obviously the individual defendant in this matter, on 4 occasions, on 4/6, 4/26, 4/28, and 5/1. And each of those occasions, he either left a business card or knocked, nobody answered. On the last 3, the gate, apparently Mr. Thompson's home, which is located in Michigan, is apparently a gated home. He was prevented access because of the gate on the last 3 of those 4 attempts. The process further indicated that he has confirmed with the county records that this is in fact Mr. Thompson's home. And by further background, Your Honor, this is the 3rd time that I have been involved in a lawsuit with Mr. Thompson. I say that because I'm going to request that the court enter an order for alternate service. But because it's a gated home and you can't get past the gate, one of the typical ways of service in an alternate service motion is by tacking. I don't think anybody is going to be able to do that because it is gated. So, Your Honor, may I suggest to the court that in lieu of tacking, that I provide which I have already done, by the way, provide a copy of the summons, the complaint, and all of the other various documents that I received in connection with this upon Mr. Thompson via email. I know that this is his email address because he has contacted me on a number of occasions using this email address.
Well, let's do this. I don't have a problem with you doing it by email, but I will want something traditionally that's there. And so typically if we tack it, somebody could tape it to the gate and you could accomplish the tacking that way.
Okay. So, Your Honor, if I serve via first class mail, tacking on the gate, if it's locked, if it's shut, if it's open, I'll ask the person to tack it on the home.
That's fine.
And by email.
Yep, that'd be sufficient.
Okay, Your Honor, may I submit a motion and proposed order to the court to accomplish service in those 3 ways?
Yep, that would work. Just get it to us and we'll you can do it on an ex parte basis and we'll get it.
Okay, I will do that in the next day or so.
Okay, good.
Thank you, Your Honor.
Okay, thank you. Have a good day.
You as well.
Should we reset the status for 1:29 p.m.? Attorney Westcott for the defendant.
Okay. Ms. Roush, I'm going to go to you first because you are the plaintiff. This is a time and place set for the status conference. What's happening on your case?
As far as I know, we were waiting to have the status conference to see where we were at.
Okay, well, maybe Mr. Todd can enlighten me. Mr. Todd, what's happening?
Yep, absolutely, Your Honor. And I guess for clarification, is Miss Reed no longer representing?
No, she withdrew.
No. Okay. So at this point, Mr. Boynott has continued with counseling. We have a letter of recommendation indicating all of the dates that he has attended counseling and a recommendation that he is benefiting and reunification should occur, and also that counseling should be decreased to possibly once a month. It indicates that the counselor doesn't believe counseling is necessary at this time. So I guess in terms of that, we're just requesting that Mr. Boynott continue to follow the recommendations of the counselor. And Mr. Boynott has reached out to blind BLND counseling. We do have an affirmative statement from Ms. Hunter that she is no longer involved with the case. So I think things are in essence kind of moving along, but I guess we would just respectfully request that an order enter that Mr. Boynott be able to just follow the recommendations of the counselor in terms of whether or not he needs to attend.
Okay. Ms. Roush, do you have any opposition to that?
No, I don't.
Okay. Well, with that, then we'll leave it to you, Mr. Todd, to prepare the appropriate order and submit it under a 7-day notice of entry from today's date. Okay?
Yep.
Okay. Ms. Roush, you'll get that within a few days, and you can take whatever action is necessary at that point. Okay?
Okay.
Yeah.
Can I ask you a question?
Yes.
When it comes to the counseling, I know he has been going to counseling, and then the reunification process is supposed to start after that. Because I know previously when we've met with counselors, we've also had to meet with them. So I didn't know, I guess I don't have any of the information for who the new counselor is and
okay.
all of
Well,
that.
what I'll do, I'll have Mr. Todd send you the report that he received with his order. So you'll have a copy of the report telling you what's happened. And then he will delineate in the order what other counseling is going forward.
Okay.
Okay.
Yep.
Your Honor, just for clarification, I'm not sure if Ms. Roush's email or address is confidential. I think unfortunately the only contact information I have for her is through her prior attorney.
Okay. Mr. Todd, do you want to give her your email address and then she can send you?
Yep.
Ms. Roush, send Mr. Todd your email address after he tells what his is. I don't mind putting his on because it's not private or privileged, confidential, but we don't want to disclose yours on streaming.
Okay.
Okay, go ahead, Mr. Todd.
Thank you, Your Honor.
Okay.
Great.
Okay, great.
Thank you.
Thank you. Have a good day.
Thank you, Your Honor.
Really core for the defendant.
All right, very good.
Good afternoon to everyone. Ms. Warner, I'll go to you first because you are the plaintiff. This is the time and place set for the settlement conference. Enlighten me what's happening in the case.
Kyle's attorney did send me a divorce settlement proposal, which I agreed to. So to the best of my knowledge, that's where we're at.
Okay. Did you sign that and return it to Ms. Greenlee-Flor?
Yes.
Okay. And Ms. Greenlee-Flor, did you receive that?
I did. It was actually submitted to it was actually approved and submitted to the court on May 2nd. So it should be with the court actually. However, I did just look at the calendar and we are not 6 months into this case yet. So that might be an issue.
Well, it might have been submitted to the front of the court, but I guess they don't like us, so they don't communicate with us.
Yeah,
So-
I sent it directly to your chambers. Let me rephrase that. I approved it and I sent another copy to you with the return envelope, but we're not 6 months in yet. So
okay. Well, do you what we'll do is we'll take some proofs and then we don't have to come back for that. Ms. Warner, we're going to take some testimony from you, so I ask that you raise your right hand and be sworn in first.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Ms. Warner, in this matter, you filed a complaint for divorce, seeking a divorce from the defendant. Prior to filing that complaint, had you resided in the county of Calhoun for more than 10 days in the state of Michigan for more than 180 days immediately preceding the filing?
Yes.
And in this complaint, you had alleged that the various things, and were all the allegations true at the time that you filed it, and do they remain true today?
Yes.
You stated that there had been a breakdown of the marital relationship to the extent the object of matrimony had been destroyed, and there remains no reasonable likelihood the marriage can be preserved. Is that correct?
Correct.
Is there any chance that you and the defendant would reconcile and live together as husband and wife?
Unlikely.
Are you currently pregnant?
No.
Okay. The court will find that the testimony does establish a statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending the running of the time frame. You have a 180-day waiting period, so we can't complete it until that time is up. But now there's no reason that you'd have to come back. That we simply, once we get the front of the court approval, then the approval was received. So we have that. We just have to wait the time frame, and then we will get the matter concluded after the 180 days. So with that, you're free to go. Have a good day.
Attorney McNiff for the plaintiff and Attorney McKenzie for the defendant.
Good afternoon to everyone.
Good afternoon, Your Honor.
Judge.
We'll go to Ms. McNiff first, as she represents the plaintiff. Ms. McNiff, enlighten us what's happening in the case.
We've gone to mediation. I think that we made some progress in mediation. We're still attempting to negotiate this. The goal, I think, is to try and settle this matter. But we might need another session with the mediator or more time at least to go back and forth. As the court knows, I've been monopolizing the court's time in trial. And this week I'm bothering the referees instead of Your Honor. So
well, that's nice of you to spread it around, Ms. McNiff.
I thought you needed a rest from me for a while, and maybe the referees could.
Only me behind your husband, Ms. McNiff.
I feel like I've seen you more than my husband lately.
Okay. Okay, so you well, we're only into it 129 days, so we have some time. When do you anticipate getting back to Mr. Brundage for additional session?
Judge, it's Carol. Mr. Brundage would be available the next week, and he said that Ms. McNiff and I could speak with him. He is sporadically available next week, but would be happy to set a time for us.
Okay.
Perfect. I could do Monday.
Okay.
Ms. McNiff, it might not necessarily be Monday. It's the week of.
Okay.
Yeah, and it could be Monday, but you and I can speak with him a little later today if you'd like.
Yeah.
Well, speak with him. What we'll do is we will, because we're early enough on, we'll reschedule this for about 30 days. And
that sounds good.
And at that point, if we don't have resolution at that point, we'll set it for trial.
Thank you, Your Honor.
Okay. Thank you all. You're free to go. Have a good day.
Hello. Thank you, Your Honor.
Hi, sorry about that. That was a little bit.
Oh, I thought your client was going to be with you because I had seen the Zoom earlier and it was set up in that conference room that you guys typically use.
Yeah, so the runner ended up putting us into that without talking to me first, and then I can have her join us.
Do you want to proceed now, Judge?
Well, it's my understanding from what Mr. Vanderhorst said that you did have resolution at the time of mediation. Is that correct?
Yes, we have everything resolved, and Mr. Vanderhorst and I just recently spoke about another issue that we hadn't addressed, and it's all settled now. My client is okay with everything, so now you know that, Joe. I have a consent order drafted up, and my client should be getting on Zoom. Let me see.
She is.
Well, that's for.
No, that's Madison, and we're plaintiffs. So
oh, okay.
I would like to be able to preserve. Let me see where he's at. Maybe he's just having some difficulties on
Let me just call this for the record. So this is 2024-244 DC.
Very good. And Miss Capture just left us, so. I think Mr. Vanderhorst, you're just too intimidating there.
I don't know. That would be rare, I guess.
That's a curse of yours, isn't it?
Well, I know my son is pretty intimidating, but me, I don't know. Hi, Madison. You got on okay, I see. You got to unmute yourself.
There it goes. I'm still trying to figure out this app. It took me a second.
Well, the attorney's muted too, so don't feel bad because she's on this thing almost every day and she's still muted. So
the moment he pops in here.
So you believe that you have a settlement, but you don't know for certain until you get signatures, correct?
Yeah, I mean, I think everything is agreed to after Joe and I spoke this afternoon. I think we are all on the same page.
Yes.
We just have to get you the order.
Your Honor, maybe I could pipe in, Katrina, too. There is a consent order in place. The only change we're really going to make in that order is we're going to take out the word temporary and make it a final custody order. And then we were going to alternate the tax exemption for that one minor child. Even years would be my client, odd years would be the plaintiff. And that was the only addition to that consent order, Your Honor, other than striking the word temporary.
Well, if Ms. Capture's client joins, then we'll maybe inquire of, in fact, why don't I get you, Mr. Vanderhorst, why don't you inquire of your client?
Sure, I will.
Conditions, and then we can hopefully have him involved.
Madison, you remember you've got one minor child, right? Waylon?
Correct.
Who's 1 year old?
Yes.
And you've been sharing equal time, a joint physical, joint legal custody with Father Nathaniel?
Correct.
And you feel that that's in his best interests at this time, the child's?
Yes, I do.
And you've got a parenting time schedule as outlined in that previous order, and that's working out well?
So far, so good. Yes, it is.
And
been doing pretty good.
Good. And we're going to just take that order and make that a final order with the addition that you're going to get the exemption for him on the even, like 24 even years, and the father would get on the odd years.
Yes.
The tax exemption. And that's about it, Your Honor. And do you believe that's a good, fair agreement then, Madison?
I believe it is.
Okay. I have nothing further, Your Honor.
Okay, thank you. Well, Ms. Capture, your client still is not joined, so.
Yeah, he's saying still trying, not having luck, trying one more thing. So
This might be, okay, this might be him just now. Let me see.
thank you. And Judge, do you want me to have him sworn in?
Well, you don't have to swear him in just for purposes of putting the settlement on.
Thank you. Nate, you're aware that there's a temporary consent order in this matter, correct?
Yes, for let's see, correct, that's what you're talking about.
Yep, and that order is in regard to the temporary custody, parenting time, and child support of your minor child, Waylon, correct?
Yep. Yes, ma'am.
And under that order, you and Miss Enyart has been operating on a week-on, week-off parenting time schedule. Is that correct?
Yep.
And within that order, there's also alternating holidays. Are you aware of those?
Yes, ma'am.
And do you agree that this is currently in the best interest of the minor child?
Yes.
And do you agree to be bound by this or by that particular order permanently, it no longer being a temporary order?
Yeah, I spoke with her and told her it worked great, and we both like it.
And we spoke recently about agreeing to alternating the tax years with you receiving Waylon as a tax deduction for the odd years and Madison receiving him for the even years.
Yep, that works.
And I believe that covers everything. Thank you, Your Honor, and thank you, Nate.
Okay, well, thank you all, and Ms. Capture, we'll leave it up to you to get all the orders done appropriately and submit those to Mr. Vanderhorst as well as the front of the court.
All right, thank you so much.
Thank you all. You're free to go. Have a good day.
Thank you. Thank you, Madison. Thanks, Katrina.
Thanks, Joe.